you ever felt your privacy was violated?
Good afternoon, everyone. First of all, I'm truly honored to be here today, and I want to thank the organizers for inviting me here to this event. Now, before we start this event, let's take a moment to appreciate the incredible dedication of our healthcare workers and doctors during the COVID-19 times. The hard work had been nothing short of heroic. Now, before we delve into the intricacies of this lecture, I'll begin with a brief video for the reference.
Imagine being in Mahesh's shoes, who discovered his personal health journey splashed across social media without his consent. This is a story about privacy, consent, and the delicate balance between sharing success stories and respecting individual rights. Mahesh, plagued by a stubborn skin allergy, found relief not in allopathy, but in the hands of a renowned homeopathic doctor, Dr. Kuti. The treatment was a resounding success, freeing Mahesh from the persistent discomfort he had been experiencing. Overjoyed with the results, Dr. Kuti decided to share this success story online, uploading videos and images of Mahesh's recovery on various social media platforms. However, imagine Mahesh's shock when he discovered his personal images and videos on the internet, shared without his knowledge or consent. A private individual, Mahesh felt his privacy had been invaded. It was a clear infringement of his rights, and he decided to take legal action against Dr. Kuti. This story serves as a stark reminder of the importance of privacy and consent in our digital age. While it is crucial to share success stories and inspire others, it should never come at the cost of an individual's privacy. Always remember to seek consent before sharing personal information online. In this era of digital sharing, it's vital to uphold the principles of privacy and respect for individual rights.
Thank you for watching the video. Now, I would like to ask a question from my audience that how many of you have ever imagined or have ever done this thing? Uploading the images of your clients on social media platform only for the educational purposes? Anybody? None? Okay, but I have seen a lot of medical practitioners doing this without even taking the consent of their clients. Now let's delve into the issue of medical negligence. Now, can anybody tell me what is negligence? Nobody? Nobody? Okay. So negligence is the absence of due care and caution. That means without following the due standards of the medical practices. Now, medical negligence can be in many cases. For example, misdiagnosis, failure to diagnose, delay in referring to a specialist, or posing just a second, let me come to the slide. Or posing falsely, for example, an Ayurvedic doctor prescribing homeopathy medicines or an allopathy doctor prescribing some other practices which are beyond their expertise. Now, long-term negligent treatment can be failure to follow up, inadequate monitoring, deviation from standard of procedure. Now, legal implications of medical negligence. The legal implications of medical negligence can be civil remedies as well as remedies under the Indian Penal Code or under the Consumer Protection laws. Now, all these remedies go side by side. Every patient who has suffered medical negligence at the hand of a doctor, they can go to the civil laws as well as criminal laws. Both these things go side and side. In criminal laws, the remedy would be the penal actions or the disciplinary actions against the doctor. And in civil laws, the remedy would be the compensation in terms of monetary compensations. Now, there can be some regulatory offsites and disciplinary actions also, like the suspension of the license, investigation, accountability by the superior courts or even by the consumer protection laws. Let me come to the another slide. Now, what is the relevancy of consent? in medical practice. Now, what is the meaning of consent? First of all, the consent means when two people agree to the same thing in the same sense. For example, it is a duty of the doctor to take an informed consent. Now, what would be an informed consent? The informed consent would be the express consent taken by the doctor from the patient. He has to disclose the entire set of treatment to the patient so that patient knows that what is going to be his treatment. Now, what is the relevancy of taking consent in medical care? Anybody? No? Okay. When it comes to the legal implications, now, consent is when two people agree to the same thing in the same sense. And we as a professional, we stand in a fiduciary relationship with our patients. So whenever there is a case of medical negligence, the court will go with the presumption that the doctor has influenced the consent of the patient, because we, doctors and all professionals, we all stand in a dominant position and we are in a position to dominate the consent of our patient. So the burden in these kind of cases is upon the doctor, that he has taken consent freely of the patient and the consent is not vitiated either by misrepresentation, either by fraud or coercion or any other manner. So therefore, the free consent is very important in all these medical negligence cases. And the court is moving with the presumption that the consent is vitiated by fraud or in any other scenarios. And it is highly important for all the doctors to make an exhaustive treatment for the patient, as well as to write exhaustively that what are the things which he thinks are best in the interest of the patient. That is to take an exhaustive medical history, so that, God forbid, if a case of medical negligence is initiated against a doctor, he can prove by using his prescription that he acted in good faith and he recommended everything to the patient concerned. This will show the good faith of the doctor. Because it is very important for the patient to know the pros and cons of the treatment which is going on against him by the doctor. And now, how the consent can be taken? Consent can be taken expressly by telling the patient or by prescribing the forms to the patient that he agrees to the line of treatment which is set up by the doctor, or consent can be implied. For example, if you are sitting in your room and a patient comes to you, that means patient has given implied consent to you to treat him. Or in case if a patient is unconscious and he is accompanied by his family members, so in that case the consent given by the family members would also be taken as an valid consent in these kind of cases. Now we all know that post the COVID-19 times, we all have adopted the practice of telemedicine, which has opened many perspectives to the doctors who are sitting in India to advise a patient who is sitting in US. Earlier, these kind of things were not very famous, but post-COVID, these things are adopted even by the Indian doctors. So now, what is telemedicine? Are you aware about the guidelines which are there about the telemedicine? Anybody? No. So there are many guidelines informed by the Government of India as well as Homoeopathic Council on telemedicine. So who can give telemedicine? Telemedicine can be given by any registered medical practitioner. Now, what are the regulatory frameworks? In March 2020, the Government of India released the telemedicine practice guidelines, providing a regulatory framework for the practice of telemedicine in the country. Any registered medical practitioner enrolled in the state medical register or the Indian medical register is permitted to provide telemedicine guidelines. Now, how telemedicine can be given. It can be given by audio or by video. And whenever you are giving any audio or video consultation to a patient, and you think and you have a reason to believe that you need the physical examination of the patient, and it is necessarily required to examine a patient personally, then in that scenario you have to inform the patient ASAP, as soon as possible, that his physical examination is necessary in the facts and circumstances of the case. Because if you don't do it, then you may enter into a realm of medical negligence. Now, consent and confidentiality in telemedicine. Whenever a patient comes to you physically, then it is very easy to protect the confidentiality of a patient. And the patient is in front of you. He can see what a doctor is doing, how the doctor is prescribing the medicine. But whenever it comes to telemedicine, the patient is not physically available in front of you. He is sitting in another part of the world and you are sitting in another part of the world. So how will you maintain the confidentiality in telemedicine? The first thing is that you can obtain a consent. The patient must be informed about the telemedicine process, how his privacy will be protected, and how his confidentiality will be protected by you or by your team, and how you will protect the data which will be collected from the patients. Consent can be obtained through email. It can also be obtained through WhatsApp messages or a video recorded by the patient that he has given the consent to you. Now, refusal of telemedicine. Again, if a patient refuses to proceed with telemedicine and prefers an in-person consultation, the registered medical practitioner must inform the patient of the risk and consequences and document the patient's decision to proceed against medical advice. Confidentiality and privacy. Registered medical practitioner must ensure the confidentiality and privacy of patient information during telemedicine consultations, that they are in line with the existing rules and medical practices. Now, what would be the misconduct in telemedicine? Now, one can be forced telemedicine. Engaging in telemedicine against a patient's preference for an in-person consultation would be considered misconduct. Misuse of patient data. Misusing patient images and data during telemedicine consultation would also be considered a breach of professional conduct. Unethical promotion. Promoting telemedicine through advertisement with proper context and disclosure would be deemed unethical and form a misconduct. Documentation and record keeping. The registered medical practitioner must maintain detailed records of the teleconsultations, including patient information, diagnosis, and prescribed treatment. Prescription records are responsible for maintaining accurate prescription records for telemedicine consultation and consultation notes. Now, what would be the advantages of telemedicine? These are improved access, convenience, cost saving, but everything comes at the cost of protection of data privacy of a patient, because we cannot get into one realm without touching the another realm. If in case of medical negligence, IPC would be attracted when it comes to criminal law, but it cannot be dealt independently. There are some data privacy laws as well as IT laws which are to be considered, and all these things are intermingled. Now, for your purpose, we have made this consent form. This is a sample consent form which you can take before when a patient comes to you. This will include the patient information, doctor information, consultation details. Now, in this consultation detail, you can write whether the consultation is a telemedicine or a physical. If it is telemedicine, whether it is in the case of a WhatsApp communication audio or it is a video consultation. Now, the language of the consent can be this: I, the undersigned patient, hereby consent to engage in a telemedicine consultation with Dr. X for the purpose of seeking medical advice and treatment. I understand and agree to the following: nature of telemedicine consultation, thereafter benefits and limitations, privacy and security. I understand that my personal and medical information will be kept confidential and secure. Patient responsibility and emergency situation. Thereafter, follow-up care, termination of consultation. You must have this clause: termination of consultation. Suppose if you have asked patient to do something and he is not complying with your guidelines, in that case you must be having a power to revoke. Thereafter, whenever you wish to use any audio, any video or any image of your patient for the purpose of educational purposes, in that case you may use the above mentioned consent form, wherein it is specifically mentioned that the patient is giving his consent that his images or his details are uploaded and he gives consent that it may be uploaded on social media platform for the purpose of educational purposes. The doctor intends to use the patient's study, including videos and images of the treatment on social media platform. Example, Facebook, Instagram, YouTube, for the purpose of spreading awareness. Because if you take this consent, then you waive all the repercussions of legal laws. Now we have some cases also which are landmark cases in medical negligence reported by the Supreme Court as well as the consumer protection laws. So this is a very landmark case, Vinay Kumar Mishra versus Man Kameshwar Nursing Home. In this case, the case involved a pregnant woman who was admitted to the Man Kameshwar Nursing Home, where Dr. Meena Pandey, a BHMS practitioner, claimed to be a gynecologist despite lacking the proper qualifications. Dr. Pandey prescribed allopathy medicines and performed the delivery, leading to the patient's tragic death. The court found that there was a total lack of medical protocol in the treatment of the patient, and the nursing home knowingly misrepresented Dr. Pandey's qualification to attract patients. The court ruled that this amounted to medical negligence and a clear deficiency in services. The court emphasized that Dr. Pandey's actions of depicting herself as a gynecologist when she was not qualified as such was a violation of the noble principles of the medical profession. This false representation led the patient to trust her, which ultimately resulted in the tragic outcome. Now, whenever there are cases of medical negligence in which doctor and hospitals are involved, it is to be noted that not only the doctor who has done the medical negligence is liable, rather the hospital in which that doctor is working would also be vicariously liable. Now, there are two things, directly liable and vicariously liable. Direct liability is of the doctor, the one who has done the medical negligence. But the court will go with the presumption that the hospital who has employed the doctor, they also had a part on their part to conduct a due care and caution that whether the doctor who is adopting a particular plan is valid in the eyes of medical law or not. Because in these cases, the hospitals will also be vicariously liable, and they also have to make compensation to the patient, because the patient is trusting not to the doctor alone but to the hospital also. Now, this is another landmark case of the Honorable Supreme Court of India, wherein the Supreme Court found that the homeopathy practitioner Dr. Ashwin Patel was not authorized to practice allopathy medicine under the Bombay Homeopathy Practitioner Act. Despite this, he prescribed strong allopathy drugs and intramuscular injections to the patient, which ultimately led to the patient's death. Now, it is a sheer breach of duty and negligence that Dr. Patel's decision to provide allopathy treatment despite lacking the necessary qualifications amounted to actionable negligence and a breach of duty. The court also emphasized that healthcare providers must practice within the scope of their training and qualifications to ensure their patient safety. Now, again, there is also a judgment of the Punjab Haryana High Court wherein it has been held that the petitioner Mamta Rani sought anticipatory bail. In this case, the doctor was arrested by the prosecuting agencies, and the court failed to give the anticipatory bail because there was sheer medical negligence on the part of the doctor. Though there are guidelines by the Supreme Court that whenever there is a case of medical negligence, and this is for all of you, whenever there is a case of medical negligence, the police cannot come to your doorstep and arrest you immediately. There are few guidelines which are to be followed by the police authorities. They have to make an independent panel of the doctors who would first consult whether the doctor was negligent or not, and only thereafter the police or the prosecuting agency will conduct the prosecution against the doctor. So in this case, the panel found that Dr. Mamta Rani has conducted due medical negligence, and therefore she was arrested and she was again refused anticipatory bail by the Punjab Haryana High Court. Now, apart from that, there are few suggestions which I would like to make to all of you so that you can avoid the situation of medical negligence in your practice. Now, number one is you must prepare an exhaustive prescription to the patient to avoid any allegation of concealment, negligence, etc. The exhaustive prescription would act as an evidence to show your good faith if God forbid the patient is taking action against you. Now, second one would be in cases of educational videos which you are using for your social media platforms, directly or indirectly, to promote your practice. In that case, you must have an express consent of your patient that you are going to use these videos for educational purposes only. Now, you can also take consent of patient either through express consent or it can be an implied consent. Express consent by way of the documents, by writing or by videography. And you can have a consent form also. Whenever you have a prescription, below your prescription you can add a disclaimer that the patient is giving you a consent to take action appropriately. And thereafter, in case of telemedicine, you must mark on the top of your prescription that telemedicine is by way of WhatsApp, email, video, audio, etc. etc. On your prescription also, mode of consultation should be there. And you can also collaborate with other healthcare professionals whenever necessary. Suppose you are dealing with a patient and you are not expertise in that area, you do not have any expertise in that area. So immediately, without wasting any time, you must refer that patient to a specialist who is an expert on that particular topic. And you must maintain your records. Whenever you are issuing a prescription to a patient, these days it is very easy to maintain soft copy records. Earlier it was very difficult to maintain humongous pages, but now you can have a record, a directory of your prescription. And avoid providing treatment outside the scope of your practice areas. And another one would be, and most importantly, if you are working in a hospital or if a hospital has employed you as a doctor to conduct OPD or anything else, then remember that due care and due negligence is very important, because in case of medical negligence, it is not going to impede you only, it is going to impede the entire hospital also. So if anyone who is operating any hospital, who is the founder of any hospital, it becomes very important for you that whenever you are employing a doctor, you must have few certain terms in your contract, which I cannot discuss here because of paucity of time. So that in case of medical negligence, the interest of the doctors as well as the hospitals can be safeguarded. Thank you for this session. Thank you.
Thank you so much.